Hi everyone, welcome to the Charlene Show, a show which talks about abuse, social, cultural, lifestyle and human life interest stories. So today we continue with the 16 days of activism against gender-based violence campaign, which has kicked off from the 25th of November to the 10th of December, which is Human Rights Day. This year's theme is better relations between men and women. And we continue on a high note as we discuss gender-based violence. Today I'm joined by Tariro Makoni, who is a public prosecutor in the Domestic Violence Court at the Magistrates Criminal Court. And she's going to talk to us about gender-based violence with regards to her work in the DV court. Tariro, welcome to the show.
Thank you so much.
I guess to start off, what do you do in the Domestic Violence Court?
The Domestic Violence Court, I guess the name speaks for itself. We deal mostly with domestic violence cases. These range from intimate partner violence, which is mostly physical violence, to emotional abuse, verbal abuse, intimidation. The scope is large. If you have gone through the Domestic Violence Act, there is a wide scope that is listed. It gives a wide range of cases that can be dealt with in the Domestic Violence Court. I've just mentioned a few of the cases that mostly come to court, but we have a wide range of cases that do come to the court.
Okay, so in the Domestic Violence Court, do you only deal with the Domestic Violence Act?
No. We deal also with the Maintenance Act. There is the Maintenance Act where we deal with people who would have defaulted in paying maintenance. So they would have been arrested on the basis that they would have failed to pay the maintenance for minor children as would have been stipulated by the court, as would have been ordered by the court. So though in cases like that come to the Domestic Violence Court as contempt of court. We also have those cases.
Mm-hmm. And let's go back to the Domestic Violence Act. Yes. Do you feel that there are any loopholes in the act?
Not as such. The Domestic Violence Act is one of the best progressive legislations in terms of gender equality, ending gender-based violence is concerned. It's one of the best progressive realizations in legislations that has ever been enacted. I guess the only loopholes that are there when it comes to the Domestic Violence Act is in terms of the enforcement. There are a lot of challenges that are associated with enforcing some of the provisions that are actually stipulated in the Act. For example, the challenges associated with police officers having to arrest people at the times when people need help the most. And the only challenge that I've witnessed is the challenge that comes to the enforcement. You will find that sometimes when people really need help, when someone is being attacked, it is really difficult for that person to access the nearest police station. And when they do get to the police stations, the police officers do not have the transport or the resources to actually come and help. And we have had cases where police officers sometimes deliberately do not cooperate for reasons that sometimes we do not know ourselves as prosecutors. And we have also had challenges with people who sometimes do not willfully disobey the protection orders on the basis that they're just papers. So you find that they willfully defy the order and they go ahead and violate and harass and abuse the other person. Yes.
So I guess this takes us to peace orders and protection orders. What are they and what are the processes?
Okay, I'll start by addressing the protection orders because these are directly linked to domestic violence. A protection order is an order that you apply for at the Harare Magistrates Court. The Domestic Violence Act lists the people who are eligible for applying for the protection order, there has to be a form of a relationship between the abuser and the respondent.
Now to protection orders and peace orders. What is the difference between them, and how can I get a protection order or a peace order?
The difference between a protection order and a peace order is that, firstly, in terms of legislation, a protection order is in terms of the Domestic Violence Act of 2007, and a peace order is in terms of the Criminal Code and Reform Act of 2004. Yes. A protection order applies to people who are related, people who stay together. They may not necessarily not be related, but people who are staying together, sharing the same roof. It could be a landlord, it could be a tenant, it could be a mother-in-law, it could be your aunt, it could be your uncle. If they harass you in any way, you cannot apply for a peace order because there is a relationship between the two of you. So instead you apply for a protection order. This is to protect the respondent, who is the complainant, from possible and imminent harm that is likely to occur. Whereas a peace order can happen between an employer and an employee, someone I just met in the streets, someone who stays 5 houses away from my house but is in the habit of harassing me, is in the habit of threatening me, or in the habit of actually assaulting me. So in that situation, I can get a peace order and not a protection order. With a protection order, there is what is called an interim order that is offered, and on that very day when the order is applied for. The interim order is to protect the victim immediately, because think of a situation whereby I apply for a protection order and then go back home to the very person who is abusing me, because it takes about 2 weeks for the actual order to be processed at the court. So there is what is called an interim order that is afforded by the court on the day when your application is made. And then the interim order will be replaced by the protection order. And then the protection order can only be revoked or varied by an order of a higher or competent court.
Okay. Yes. Wow, that information is so informative. So I see you love your work as a public prosecutor, and having to work in a domestic violence court every single day. What are your feelings with regards to?
My feelings towards gender-based violence as a public prosecutor are that I feel that I have a big responsibility to bring perpetrators of domestic violence, especially gender-based violence, and violence that occurs to relatives. I feel like I have the responsibilities of bringing the perpetrators to book. People need to be held accountable for their deeds. No amount of violence is too small to be ignored. Violence affects people differently. That's why the domestic violence has a wider scope now. It covers emotional abuse, financial abuse. As a prosecutor, it is my responsibility to make sure that all those abuses are dealt with. People are safe, people are living well, and that the law does take its course.
Okay. And what happens now? Because when we talk about domestic violence, does it always have to be, okay, so when we talk about domestic violence, are we always looking at whether the victim has got bruises or not? And what happens have there ever been cases whereby someone is lied to? And if yes, what can be done? What is the remedy?
Answer the first question. Domestic violence, the victim does not have to have bruises. Like I mentioned, that domestic violence, the scope is wide. It goes beyond just physical abuse. It goes to emotional abuse. It goes to harmful cultural practices like child marriages, genital mutilation, marrying young girls off to appease spirits, all those are captured under the Domestic Violence Act. We also have emotional abuse, we have stalking, we have malicious damage to property, that's domestic violence. So you see, it has nothing to do with bruises, but it's still violence, you see.
But in the case whereby it becomes physical, does the person have to have bruises? And what if the victim is lying? Have you ever encountered such cases?
If the victim is lying, yes, we have encountered such cases as a court that deals with a wide range of cases. But through cross-examination, sometimes it is very easy for even the magistrate or the prosecutor to tell that this complainant is not being truthful through inconsistent statements, and sometimes they do not want to avail their medical affidavits if they are not being truthful because they do not have tangible evidence in the case of physical abuse. But in cases where it's emotional abuse, we do not expect to have medical affidavits because there is no physical damage that has happened. You would find that domestic violence, right, as I've mentioned before, the scope covers more of other forms of violence and also physical violence. So you would find that if it's a case of threats, intimidation, harassing, unwanted phone calls, stalking, those cases like that, there is no evidence of any physical violence, but it is still domestic violence. Any physical bruising, we cannot have any tangible evidence of physical bruising, but that all is still domestic violence.
So everyone who faces any form of domestic violence can come to the domestic violence court.
Any person can apply, and what I love most about the Domestic Violence Act is that it gives provision for someone to apply on behalf of the victim. Take for example, I have noted that you are being domestically violated, right? For example, it might be your mother, it might be your father. I can apply on your behalf. You do not even have to be there. I can apply for an order at the civil court on your behalf, and that order will be binding, and if violated, that will actually be contempt of court.
Wow, thank you so much for such information. I'm sure most people didn't know that you can apply on someone's behalf. So as a women's rights activist, any advice, any message you'd like to give to Zimbabwe?
The message that I would want to give to Zimbabwe, I want to encourage victims of violence to always speak up, to confide in the law. We have the law, we have the criminal code that is there to assist. We have the Domestic Violence Act. We have a lot of international instruments that are there to assist victims of domestic violence. People do not need to bottle up. You speak to someone, get assistance, might be legal assistance, and also I encourage healthy communication between couples, because I've observed that most of the times when people actually do fight, or when people verbally exchange words, it is because of anger that has been bottling up for a long time, and they finally express this anger through fighting. So I encourage couples to talk. They should have healthy communication. They should by all means seek counseling if they can afford. And if someone is being abused, they should report. They can go to the civil court and get a protection order. You may not have been assaulted at that time, but if someone is promising to assault you, you can still get recourse. It might be imminent danger or non-imminent danger, but you still have to be protected by the law.
Thank you so much, Tariro. That was Tariro Makoni, a public prosecutor in the Domestic Violence Court. As we heard, You don't have to be the victim to go and seek recourse. You can apply for anyone. And the message still remains, you should speak up, you should speak out. If you are a victim of domestic violence, don't keep it to yourself. Go and report. The victim-friendly court, victim-friendly unit is there to help. The magistrates court, domestic violence court is there to help. There are organizations that are there to help and willing to hear your story. Your story as a victim is not yours alone, but it is everyone's concern. Let us help each other and stop domestic violence. Let us help each other and stop gender-based violence. Let us orange the world. Until we meet next time, bye.